Dodd-Frank is a significant piece of federal legislation that impacts virtually every aspect of financial services in the United States. It will also have an impact on companies raising capital in what are called private placements. There's two significant changes in Dodd-Frank that will impact private placements. First is modification of the definition of accredited investor, and the second is the adoption of what are called the bad boy rules. First, we need to discuss and understand what a private placement is. Under the federal securities laws, when a company is raising capital, every offer and sale of a security in the United States must be registered with the Securities and Exchange Commission, or there's an exemption from registration. There are many exemptions from registration that are available to companies. The most widely known is called Regulation D. Under Regulation D, there are three discrete exemptions commonly known by their rule numbers: Rule 504, 505, and 506. Rule 506 is by far the most relied exemption from registration. Rule 506 offerings are very beneficial to companies, principally for three reasons. The first reason is the rule itself is very simple to comply. It has very few elements to a test. The second reason, there's no prescribed disclosure as long as all the offerees are accredited investors. If a company is selling to non-accredited investors, there is mandatory disclosure, including in certain circumstances audited financial statements, which many privately held companies do not have. The third benefit to Rule 506 offerings is that companies raising capital will not have to register or qualify their securities in the states where the offers and sales are made, only making a simple filing with the state securities regulator, and tends to be a small fee. Rule 506 allows companies to raise capital, an unlimited amount of money, from an unlimited number of accredited investors and up to 35 non-accredited investors, provided the company offers the securities not through a general solicitation or advertising, and also imposes certain resale restrictions on the investors. To understand a Rule 506 offering, you have to understand the definition of accredited investor. There's two types of accredited investors: natural persons and entities. Entities consist of institutional investors such as banks, mutual funds, hedge funds, large corporations. Natural persons can also qualify as accredited investors. There's two types. One is under the net worth test. Essentially, any person with a net worth in excess of $1 million qualifies as an accredited investor. The other test is a net income test. Any person with a net income over the past 2 years in excess of $200,000 or $300,000 along with that person's spouse, and who reasonably expects to make that income in the current year, also qualifies as accredited investor. As long as the company offers its securities to accredited investors, it can qualify under Rule 506. What Dodd-Frank does is modify the definition of accredited investor for the net worth test. It now has imposed a requirement that in calculating net worth, you exclude the investor's primary residence. Our experience has been that it will not have a significant impact on private placements, in that most investors who meet the net worth test will continue to meet the net worth test, notwithstanding exclusion of the value of their primary residence. The second change to accredited investor imposed by Dodd-Frank is that Congress is instructing the SEC to review the definition of accredited investor from time to time. Regulation D is nearly 30 years old, and the net worth and income tests have not been adjusted for inflation or otherwise, and Congress has instructed the SEC to periodically review that definition. The other significant change by Dodd-Frank is the imposition of what are called the bad boy rules. Historically, the bad boy rules have only been imposed on certain other exemptions from offering, but are now going to be imposed on Rule 506 offerings. The bad boy rules essentially state that certain control persons of the company or its placement agent, if the company is using a placement agent in its offering, cannot have violated certain securities and other financial regulations. The Securities and Exchange Commission has recently proposed rules to define who those covered persons are, officers and directors and promoters, and also to define which particular violations by those covered persons would prohibit a company from relying on Rule 506 private placement. Probably the most significant covered person in the proposed bad boy rule is the 10% beneficial owner test. These are going to be people who are outside investors of the company who own more than 10% of the company. The reason it will become an issue is that companies that rely on 506 offerings tend to be larger companies, could also be publicly held companies, and determining whether or not these 10% beneficial owners have violated the bad boy rules will cause some of these companies to either go through certain steps to make sure they comply with the rules or not do Rule 506 offerings at all. There will be some companies in a transition period that will certainly look at the rules and whether or not they can complete their current offerings prior to the imposition of the rules. Companies will also need to look at its officers and directors and other control persons and its 10% shareholders to determine whether or not those particular individuals comply with the bad boy rules. And if not, which steps the companies can take in the future to either remedy the circumstance or simply avoid Rule 506 offerings in the future. The imposition of the bad boy rules on Rule 506 offerings will also impact the investors. They will see in the subscription documents a line of questions now on their particular background. Institutional investors will be questioned about their officers and directors and control persons and whether or not those individuals are in compliance with the bad boy rules. Under the Dodd-Frank changes, companies are going to be faced with significant challenges, particularly with the imposition of the bad boy rules. It's going to depend a large part upon the Securities and Exchange Commission's final rules when they are adopted, and also the particular company's facts and circumstances. Closely held companies may not be quite as difficult. Obviously, publicly held companies or private companies with a significant stockholder base will be much more difficult to comply with some of these rules. Ultimately, it's going to come down to how the SEC shapes these definitions in its final rules.